People who think running up a $100 tab at a restaurant proves you're rich. And gentlemen, welcome to part 2 of our smackdown of loser McCain is through, the lone woman behind a distorted voice, and our debunking of her. What the heck was the title of that? Bush versus Bill Clinton FISA, July 2009 video. Moving on, now that Obama has reauthorized the Patriot Act after calling it a shoddy piece of legislation and blaming the Bush administration for conducting warrantless surveillance, he shows his hypocrisy. Obama has to know all the items we're going to go over here, so let's start with this, and it'll make you wonder why he reauthorized it and why a Democrat Congress reauthorized it. During his Senate Judiciary Committee confirmation, current AG Eric Holder stated his support for the part of the Patriot Act that allows for the FBI to seek records from businesses, libraries, and bookstores as the policing agency investigates suspects in this country. And we have this delicious irony too. Pay attention, McStupid. Obama's Department of Justice went to court defending a Bush administration wiretap. The now defunct Al-Haramain, hope I'm pronouncing that right, Islamic Foundation sued the government, contending they had been illegally wiretapped. Unlike most litigants, they were able to prove it because the government accidentally delivered a document to them that explained their personnel had been targeted for wiretapping. The Obama Department of Justice merely sought to block the suit under the state secrets privilege. It never mounted a direct legal defense of the NSA program in the Haramain case. Obama's Department of Justice failed to produce a warrant and will probably just chalk this one up as a loss. Did you know that, McStupid? No, you didn't, because you're an idiot. Remember, Obama reauthorized the Patriot Act, but he had to know this as well. In a report issued January 21, 2010, Justice Department Inspector General Glenn Fine shows that the FBI routinely broke the law for several years by demanding telephone records through informal methods that were not authorized by statute. So they don't even follow the statute. They got laws and they just say, well, we'll take a shortcut. The abuses, which involve thousands of records, are especially striking because it is not very hard for the FBI to obtain this information legally. The Electronic Communications Privacy Act allows the Bureau to demand records from phone companies under a national security letter, signed by the director or an official he designates. Under FBI policy, any special agent can sign an NSL, which simply states that the records sought are, quote, relevant to an authorized investigation to protect against international terrorism or clandestine intelligence activities, unquote. In 2003, FBI officials began dodging this minimal requirement by asking telecommunications carriers to supply records without the legally required NSL due to special circumstances, and promising to provide an NSL after the fact. The so-called exigent letters, which were often used when no emergency actually existed, were an extra-legal contrivance that violated ECPA, Bureau policy and guidelines issued by the Attorney General. The retroactive NSLs promised by the exigent letters often failed to appear because there was no authorized investigation to which they could be linked. To fix that problem, FBI officials resorted to another illegal procedure, issuing blanket NSLs tied to no particular investigation. So he had to know that. Why did he reauthorize it? Here's another tidbit for everyone. The 2009 wiretap report has just been released by the Administrative Office of the U.S. Courts. The headline findings: 2,376 wiretaps were authorized for criminal investigations last year, of which 663 were federal and 1,713 were issued at the state level. These numbers don't include FISA wiretaps, pen register requests for communications, metadata, or orders to acquire stored emails sitting on a server. We'll get to emails in a minute. The vast majority of wiretaps, 86%, were part of the drug war, with the average wiretap bill running about $52,200. So, listen folks, I don't like drugs, they're deplorable, but can we please quit using these resources to catch morons snorting white powder into their nose? The government doesn't deserve the power to tell you what you can and can't put in your body. The Patriot Act was not intended for the drug war, it was intended for terrorism. In 2002, the federal government sought 4,103 pen register orders affecting 6,540 people's phone lines. By 2008, that number had risen to a whopping 11,126 pen register orders affecting almost 14,000 people's phones. In other words, an increase of more than 171%. Bear in mind that's 13,998 people having their call behavior monitored in real time just at the federal level, and not counting foreign intelligence pen traps under FISA. In 2002, the U.S. Marshal Service sought only 556 pen registers, compared with 1,703 for the FBI and 1,841 for the DEA. That had grown nearly tenfold by 2008 to a stunning 5,475, far more than the 2,092 sought by the FBI or 3,260 for DEA. This surely is the figure that cries out for further inquiry. Why is the USMS doing 10 times the amount of traffic surveillance they conducted in 2002, the United States Marshal Service? That is, listeners should also be informed that you do not need a FISA warrant to intercept purely foreign communications that go through our switching networks. Maybe this is why Hussein Obama and a Democrat Congress reauthorized the Patriot Act. Listen up. The Obama administration has argued that warrantless tracking of cell phone usage is permitted because Americans enjoy no reasonable expectation of privacy in their, or at least their, cell phones' whereabouts. U.S. Department of Justice lawyers said that a customer's Fourth Amendment rights are not violated when the phone company reveals to the government its own records that show where a mobile device placed and received calls. These claims have alarmed the ACLU and other civil liberties groups, which have opposed the Justice Department's request and plan to tell the U.S. Third Circuit Court of Appeals in Philly that Americans' privacy deserves more protection and judicial oversight than what the administration has proposed. It's not only cell phones coming under fire. Keep in mind, Obama reauthorized this. Google and an alliance of privacy groups have come to Yahoo's aid by helping the web portal fend off a broad request from the U.S. Department of Justice for email messages, CNET has learned. Yahoo has been quietly fighting prosecutors' requests in front of a federal judge in Colorado with many documents filed under seal. Tuesday's brief, this was some time ago, from Google and the other groups aimed to buttress Yahoo's position by saying users who store their email in the cloud enjoy a reasonable expectation of privacy that is protected by the U.S. Constitution. On December 3rd, 2009, the U.S. Magistrate Judge Craig Schaffer, one or the other, ordered Yahoo to hand prosecutors certain records, including the contents of email messages. Yahoo divulged some of the data, but refused to turn over email that had been previously viewed, accessed, or downloaded and was less than 181 days old. Justice Department prosecutors told Federal Appeals Court that Americans enjoy no reasonable expectation of privacy in their mobile device's location, and that no search warrant should be required to access location logs. The Obama Justice Department eventually dropped its bid for certain Yahoo email messages. And lastly, in fiscal year 2008, federal courts issued 763 sneak and peek warrants. Only 3 were for terrorism cases. 65% were drug cases. Again, for terrorism, not drugs, not some guy snorting coke or smoking dope. The sneak and peek warrant allows investigators to break into the home or business of the warrant's target and delay notification of the intrusion until 30 days after the warrant's expiration. This capability was sold to the American people as a necessary tool to fight terrorism. So Obama had to know all this. He knew all this and more. Blasted the Patriot Act during the campaign, but I guess that expired because the Senate passed it on a voice vote. The House overwhelmingly approved it. So what happened, guys? The Democrats were playing the Republicans are going to spy on you. Bush is spying on you. And of course they were lying or uneducated when they said Bush was the first person to do it. Wrong. So what happened, McStupid? What happened to Obama? Do you feel like you've been used? He said he was going to end the war in Iraq. He didn't do it. He said he was going to do something fundamental to the Patriot Act to change it. He did not do it. McStupid, you're an idiot. You're a zombie. And don't thank us now for correcting you. Have a nice day.